I think we can start. Good afternoon, participants of our webinar organized together with Asters, Freshfields, and Ukrainian Wind Energy Association. And today we will talk about protection of investments for renewable energy in Ukraine. And so I started to share my screen, and for your information, I muted all microphones as administrator of this webinar, and I hope you can hear me. So today we will have the following agenda for this event, and the urgency of this event is quite important. In Ukraine, as you know, there was a renewable energy boom for the last couple of years. And last year, there have been some discussions on changes in the renewable energy framework. And in this regard, usually when governments are trying to change regime, we have a topic of arbitration to be discussed in order to protect the interest of investors. And for these purposes, we have decided to conduct this webinar and explain to you some specifics of what is going on at the moment in Ukraine in renewable energy. Also, we will cover some basic aspects of investment arbitration and how it can protect renewable investments. And also we will cover issues related to negotiations with the government and issues related to initiation of investment arbitration, the procedure, what remedies are available, what costs and duration of arbitration. And also we will discuss the topic of damages and some practical examples of other EU states. For our webinar, we have the following speakers. It is Rubins QC, who is a partner of Freshfields in Paris, and he is the head of international arbitration practice. And he is also head of global CIS in Russia dispute resolution group. We will have also Markiyan Kliuchkovskyi, partner of Asters, and who is head of international arbitration and cross-border litigation practice group. Myself, Yaroslav Petrov, partner of Asters and co-head of energy, natural resources and construction practice group and member of international arbitration team. And Maria Puchina, who is associate of Freshfields. Some housekeeping rules. As explained, your mics are muted, and if you would like to say, you should turn on your mic. And Q&A session will be after each presentation. And you can write your questions in the chat, or you can use the button, raise your hand. It is available in the chat properties. And time for presentation is 15-20 minutes, and we will record our webinar. So now I give floor for welcome remarks of Ukrainian Wind Energy Association. Galina, please.
Dear participants, dear speakers, on behalf of the Ukrainian Wind Energy Association, I am pleased to welcome all of you. Topic of our today's webinar, I will remind renewable energy sources investors in Ukraine, what protection can investment arbitration offer to them. It's very important and crucial now for our market. Unfortunately, Ukraine is now suffering from energy crisis caused by unbalancing functioning of national electricity market and resulted in a deficit of the guaranteed buyer a single off-taker of renewable electricity, delayed payment, curtailments of green electricity, and some other problems. As you know, early December last year, two associations, the European Ukrainian Energy Agency and the Ukrainian Wind Energy Association, applied to the Dispute Resolution and Negotiation Center at the Energy Community Secretariat with respect to potential changes in the legal and constructural framework for the renewable energy projects. Our association is making all efforts to protect wind energy projects in Ukraine, especially those being under construction. The third association, Ukrainian Association of Renewable Energy, has also recently joined the mediation process. I will not give more detailed information about the market because I know that Yaroslav will do it. So just a few words about the Ukrainian Wind Energy Association. Public Union Ukrainian Wind Energy Association is the largest renewable energy industry association in Ukraine. It's a non-profit organization founded in 2008 to protect the interests and support the activities of the Ukrainian wind market stakeholders. The members of our association represent 100% of wind energy producers in Ukraine, plus wind turbine manufacturers, national and international, investors, lawyers, engineering and consulting companies, construction and logistic companies. Ukrainian Wind Energy Association work closely with different national, international, regional, local authorities, and we are full members of the World Wind Energy Association and Wind Europe.
Thank you very much.
Today we will have a very interesting and brilliant speakers, and I wish all of us a very constructive and successful webinar. And now I have a pleasure of giving the floor to Yaroslav Petrov, partner of Asters. Please.
Thank you very much, Galina. Andrei Konchenkov, who is a chairman of Ukrainian Wind Energy Association, could not join us because currently he is about to start negotiations with the government on the future of renewable energy. I will talk about this later. And thank you very much for Galina for the introduction on behalf of Ukrainian Wind Energy Association. So let's start with the first topic. So the situation on the market is quite interesting. And last year in September, we had the first signs of potential changes in renewable energy regime. Basically, some of this talk started in summer as rumors, and officially the first statement about potential changes was in September. It was a Parliament committee meeting where this topic was discussed, and basically we mark it as a starting point on the issue. And in my presentation, I will try to cover chronology of what was happening and what is the current situation. So the process started in September, but you can see in the red part of the slides that it is May now, and unfortunately at the moment we don't have a draft law which is elaborated, and the green tariff effectively is not changed. So basically we have the regime which was effective last year. And so basically in terms of green tariff, the situation has not changed, but eventually the industry is in a crisis at the moment, and it is in the crisis not only because of the renewable energy issues. It is also many aspects which are influencing the crisis in Ukraine at the moment. It is connected with the imports of electricity from Belarus, and it is also suspensions of working of coal-powered power plants, and also reduction of capacity for nuclear plants, and reduction of demand from the side of consumers, which is also causing issues in the market. So situation is difficult, but let's come back to the issue of renewable energy. So after the first discussions in September, in October last year, there was a first draft law registered. The draft law was actually aiming not to cut the green tariff, but it was aiming to introduce curtailment for produced electricity for projects above 150 megawatts. And in Ukraine, there are several projects above this capacity. And so the draft law was targeted with respect to specific participants. And it was in October. Luckily, this draft law was not supported by the parliament, but it was kind of also start of legislative activities. So in October, December, there were a number of public discussions at the level of Ministry of Energy. So every 2-3 weeks, Ministry was meeting with representatives of investors. So they were discussing potential changes. They were discussing different options to resolve this issue. So basically, it was quite productive and very useful exercise. But unfortunately, a part of discussions we didn't move forward. And then in 28th of November, the Ministry of Energy published its draft, and this draft was also triggered registration of several other drafts by members of the parliament, but the draft of the Ministry of Energy, it was distributed among market participants, but it has never been registered in the parliament. So basically, it was the position of the ministry, but it didn't move forward. But this draft law of the ministry was actually used by members of the parliament, and in October, in December, there was a draft law. On 6th of December, there was draft law 2543 registered in the parliament. It was initiation of members of the parliament, and the draft law was supported by investors. And investors were supporting it because it actually provided voluntary option for investors to choose either to remain in the current regime or to switch to a voluntary reduction of the tariff. So basically, the market was supporting it, but unfortunately, the committee of the parliament didn't support this draft law, and it didn't move forward. Then in December, 17th of December, 28 investors approached the president of Ukraine, and they asked to support the industry. Considering that the law 2543 was not supported by the parliamentary committee, there was alternative draft law 2543-1. It was also very similar to the previous draft law, also initiated by members of the parliament and supported by investors. But unfortunately, the law was not voted in the parliament. Then in January, there was a start of mediation. Mediation was started by the European Ukrainian Energy Association. Just a second, I will mute everyone because for some reason I hear background noise. So basically the mediation started in January 2020. It was initiated by Ukrainian Energy Agency. And this claim was also supported by Ukrainian Wind Energy Association. And starting from, I think on 25th of January, there was a first meeting as part of mediation. And as part of mediation, several working groups were established. And so there was a quite important exchange of information from the side of investors and government, which helped to clear many of the issues. And mediation is still going on, but it is on its completion stage. But after the mediation started, there was also development in January when some incentives for investors which existed and promoted renewable energy were eliminated. For example, we had a VAT-free regime for renewable energy, and in January, this privilege was changed. So in the middle of negotiations with investors, there was a change of government in March of this year, and between March and middle of April, there was no Minister of Energy. So basically, without the Minister of Energy, it was not possible to do effective resolution of this dispute. And only in the middle of April, Olga Buslovets was appointed as acting Minister of Energy. So currently, we still don't have a permanent Minister of Energy. And in April, as part of mediation, investors submitted their final proposals to mediator. And mediator is Dirk Bushler, who is the General Counsel of Energy Community Secretariat, and he is Vice Director of Energy Community Secretariat. And on 24th of April, when after acting Minister of Energy was appointed, the Energy Crisis Response Team was established. And on 24th of April, there was the first meeting of this Energy Crisis Response Team. And at this meeting, there were several statements made about future of renewable energy, and it was stated that the government is planning to sign a memorandum of understanding, which will envisage a decrease of feed-in tariff. And also there was a quite controversial statement about potential ban on construction of new solar and wind power plants, which are actually under construction, and pushing them to auctions. And there was also some statements about responsibility for balancing, and some other important statements were discussed, but the most important I covered. Then after this, in May, we have the following developments. After that statement of the crisis response team, on the 5th of May, there was another roundtable in the parliament. And at this roundtable, it was aiming to discuss crisis in the energy sector. And there was also quite controversial statement of one of the commissioners of the regulator. And the statement was also about suspension of construction of projects until balancing issue is resolved. On the 8th of May, Ministry of Energy received from the mediator draft memorandum of understanding as part of the mediation. And on 14th of May, the Prime Minister of Ukraine had a meeting with renewable energy investors where they discussed this memorandum of understanding and options how to resolve the issue with renewable energy. And today there is a meeting in the government to discuss and finalize the memorandum, and there is a chance that this memorandum will be finalized and signed, and based on the memorandum, necessary draft legislation will be adopted, and it will help to resolve the problematic issues on the market. So it is what was going on in terms of potential discussions on changes in the renewable energy regime, but the changes which were discussed, they were of different levels. So it was about potential changes, reduction of the green tariff, and also potential cut of the validity of the PPA and other issues. But a part of discussions on changes in the green tariff regime, I would like to discuss some updates of what's going on the with respect to operational projects. Starting from autumn last year, we have seen situations of curtailment of wind projects. It was for projects operated by DTEC. And in winter, there were several situations which were caused by weather conditions and also situation in the grid. And in spring, there were more and more curtailment situations. Starting from April, there were numerous situations when operating projects were disconnected for different periods of time due to issues in the grid. And it was anticipated because last year, the number of commissioned projects was quite significant, and by the end of last year, total installed capacity is for renewable energy, solar and wind, is approximately 6 gigawatts, and last year the commissioning of projects was almost half of this size. So based on this, there is a very significant impact on the grid, on the balancing, and partially this is causing curtailment. And also, despite of the curtailment issues, we also have now problems with payment for green tariff. So we have a problem of problems with liquidity of the granted buyer of taker. And the latest statistics which we have from our clients is that for February it is 95% paid, March 10, and April 5. And the delays for payment for renewable energy started last year. And last year there were also some issues which impacted payment to renewable energy. It was changes in our electricity market. So starting from 1st of July, we have a new electricity market. And according to the new electricity market, we have a new system for payment for renewables. In the past, it was everything was paid by the wholesale electricity market, and now it is different sources of money which are accumulated by the granted buyer. And one of the problems was that there was some litigation initiated against our TCO, who was also collecting part of this money, and the tariff of the TCO was challenged for renewables, and there were also other issues which impacted payment stability for green tariff. But these payment issues were actually discussed during the mediation, and this memorandum of understanding is actually considering what issues should be done. And with respect to curtailment, according to legislation, all curtailment situations should be paid. They should be compensated, during this spring, the TCO, Ukrenergo, and investors, they had a working group, and they developed methodology and the changes to legislation which would help to compensate for curtailment situations, because before that there was no kind of mechanism to compensate it. So these suggestions were sent to the regulator, and we are waiting for the adoption. So this and many other issues will be resolved during as a result of the memorandum of understanding signed with the investors. So what is the position of investors? So position is the following. So basically, as part of this process of negotiation with the government, it was clear that many of the investors are ready for voluntary reduction of the tariff in exchange of longer PPA. So it was one of the first statements during the negotiation process. And also it was important to state that the problems which we have now in the energy sector, they are not caused only by renewable energy. So it is there are many different aspects which should be considered in order to stabilize the situation. So it's it is important to mention. And so investors are ready to investors are waiting for the response from the government. What will be the next steps, and there is a quite good chance that there will be positive solution of the mediation, and the memorandum will be signed, and the necessary legislation will be adopted, and in such situation the market will start working, and projects which are on hold will continue. But at the same time, during the negotiation process, there were signals that several investors actually prepared trigger letters, and they're ready to go to investment arbitration to protect their interest. And if the situation will not be resolved, and there will not be a solution found between the government and investors, we may see investment arbitration against Ukraine. And from my side, this is it. And if you have any questions, please ask.
Yaroslav, you may want to explain to people that they can manually unmute their lines if they want to.
Yes. So basically, you can find the unmute button, and you can ask the question.
There's a question for you. Did you see that, Yaroslav, about the MOU?
No, just a second. I'm trying to stop. Oh, yeah, sorry.
It says, this is from Anatoly. He says, what is the final version of the MOU agreed by the parties? An excellent question I was going to ask myself. What does the document look like, and what is in it?
So basically, we as members of Ukrainian Wind Energy Association, the board of the association, and some key experts, we had a chance to review the draft, but it is still under consideration, so I cannot share details, but basically the document envisaged several options for investors. So basically it envisaged 4 options, and during on Friday, one of the participants of mediation in one of the TV shows disclosed that there will be four options for reduction of green tariff. So basically, in all of these 4 options, reduction will take place, voluntary reduction. So we assume that there will be option of having existing regime, and there will be also option for voluntary reduction of the tariff. And basically, with every option, there is also issues, different issues, how to respond to balancing. So basically, in cases when the amount of reduction differs with respect to the approach of investor to compensation for balances. So if, for example, investor would like to take more risks, the reduction of the tariff is higher. If investor would like to be compensated for curtailments and have a more soft responsibility for balances, the amount of the reduction is different. And also in this memorandum, there is information about cutting off period. So basically, period during which investors can continue construction of projects. So basically, it will provide answer for investors who actually we're not sure how long they will have time to finish their projects, because one of the demands for the government was actually to introduce a cut-off period. So in media, it was reported in the past that the government was stating that solar projects should be cut off by July this year, and wind projects by the end of this year. So it was discussed previously, but as a result of this mediation, we'll see what will be the position. So hopefully it will be a situation which will be more acceptable. But it is not likely that for solar there will be extension of this cutoff period. So the issue is about wind, what will be the final number and date until which projects can be built under the green tariff. But if the projects cannot be built under the green tariff, there will be opportunity for them to participate in auctions and implement the projects as auctions.
So, Yaroslav, there's another question.
Yes.
So this is from Mr. Kopcioglu, Onur Kopcioglu. He says, what is the accepted or supported deadline, completion of construction, grid connection of the projects, both for solar and wind, by the investors according to the draft laws 2543 and 2543-1? And what is your expectation as to the deadlines to be issued by the new law? When do you think it will be clear according to the law? Thank you.
Yes, basically this draft laws 2543, basically they are not under consideration of the parliament, so they were registered, but they didn't move forward. So I don't think that there is any chance for them to proceed. So what we should expect, we should expect that as a result of the mediation, there will be a new law, which will be suggested by and submitted to the parliament by the cabinet of ministers. And this law will stipulate all the issues for the amount of reduction and for the amount of for the cutoff period, for commissioning dates, and curtailment issues.
So Mr. Kopcioglu now continues with his question. He says, you stated during your speech that the cost of the curtailment should be paid according to existing law. It's paid as feed-in tariff or as, is it paid as feed-in tariff or as market price? What should be understood from the curtailment of projects of greater than 150 megawatts?
Yeah, basically the curtailment provisions under the effective legislation are the following: that in case of curtailment, investors should be compensated for this curtailment. But the problem is the law is not specific enough with respect on the amount, and that is why, in order to make this provision effective, in February, March this year, there was a group under the regulator, under the Ukrenergo. And so even despite of this quarantine, it was very active with the meetings online, and there was changes to the legislation developed by this group, and they actually drafted a methodology which will help to compensate the curtailment. But as far as as far as I remember, there was also there was no final solution on the amount as a result of this working group. There were some discussions about compensation of the market price and some discussions on compensation under the green tariff and how to compensate this, whether to add it to the tariff of the TSO or other options. So it is very important topic, and still we will see what will be the position of the regulator after they consider these draft documents. With respect to curtailments of above 150 megawatts, it was kind of very controversial situation when the draft law, which was registered by Andrei Gerus, who is now head of Parliament Committee on energy issues, registered draft law, and everyone understood that basically it was directed against one developer. And luckily the draft law didn't move forward. But as part of the discussions which are taking place now, the topic of curtailment is in place, and for curtailment there are no differences with respect to capacity of projects. So basically right now the discussion is about whether you are compensated for any curtailment or for curtailment above a specific number of hours which project we've been curtailed. So no questions, maybe. So we can move forward.
And I think it's a great way for people to ask their questions. You're welcome to speak out as well. But if it occurs to you while someone's speaking, you don't want to interrupt, feel free to use the chat function, as our two questioners have already done. You can do it as you go along, and then when we get to the question and answer session, one of the things we'll do is try to go through all of the questions that have come in on the chat as we go. Yeah,
absolutely. And I think we can move forward with a presentation of Maria. So Maria, the floor is yours, and I will turn on your presentation.
Thank you very much, Yaroslav. Hello, everyone. Thank you so much for joining our Zoom conference today. I would like to talk about investment arbitration and provide you with a short introduction to what it is.
And Masha, before you start, you might want to try to turn on your video if you can, so people can see your face.
Yes, so the issue is my video is a bit of a problem, but I'll try to do it now.
But if not, don't worry. Don't worry about it.
Apologies, I think there's a bit of an issue, but my video is actually on a different person, which is Caro de Souza, rather than mine, because I'm using two devices at this point. Anyway, coming back to the topic of our discussion today, what is investment arbitration? Well, in the past, states and investors were resolving their problems through diplomatic protection, through local courts, and that wasn't always a very sufficient way of resolving a dispute. Therefore, about 100 years ago, there arose kind of a possibility for an investor to sue the state directly on the basis of a consent. That consent can be achieved or is available through various instruments. One of the instruments is an bilateral investment treaty, a BIT, and multilateral treaties as well, which is NAFTA, Energy Charter Treaty, etc. It can also be available through national legislation and direct agreement, a contract. It is worth noting that a single project can be covered by various instruments. For example, there can be a few BITs available, a national legislation law that is available as well. And it is important to consider those when an investor is looking at its protections in a particular state. Why a BIT? A BIT is a legal agreement pertaining to investment protection between two states. It usually covers issues of access to arbitration, reasonableness, security for the investor, non-discrimination, transparency, and dispute resolution points. Yaroslav, apologies, that's my next slide now. Aims of the BAT, or as well as other international instruments like a multilateral investment treaty, is to stimulate economic growth in a state, essentially in the host state, in our situation that is in Ukraine, to achieve mutual benefits for the investor and the host state, because obviously a BAT provides an additional layer of security for an investor going to an unknown territory, for example. A BAT also establishes substantive guarantees, provides direct access to international arbitration, and generally has a balanced approach to arbitration. Next slide, I want to talk about issues about who's protected. Usually that is individuals and companies who are nationals, citizens, or residents of a party that is of a state party to the treaty. Most common criteria for companies is incorporation, seat, and sometimes substantive economic activities, management and control by foreign nationals. Restrictive or expansive, it really much depends on a particular BAT. For Ukrainian BATs, I understand that requirement of a seat can be found in approximately 15 treaties. Its seat and business activity in about 5. Its main office or headquarters, again, in about 5 BATs. Its legal address in 2, and registered office in another 2 BATs, and a registered seat, central office, or main business activity in 1 BAT. What is protected? That is my next slide. Definition of investment really varies, and again depends on a treaty or an instrument we're talking about. But generally it includes movable and immovable property and property rights, shares and other interests in companies, title or claims to money and contractual rights, intellectual property rights, and concessions and other public law rights. Again, depending on the situation, that is not only relevant for renewables. A BAT covers usually a great variety of investments, and then that situation provides protection.
And I should say, if you don't mind, Masha, I'll just jump in here. The question for the renewable energy investors is, well, how does this apply to us? Usually it's going to be quite clear in a renewable energy situation because either the claimant owns a renewable energy facility that it operates, or it owns shares in a company that owns the same, and the investment would be the shares in that company, whether normally a local operating company, a Ukrainian company. There's also a sufficient jurisdictional hook in terms of finding an investment, in terms of the value of your rights under the power purchase agreement, or other contractual or non-contractual rights that you have. So normally, and I could say this in relation to the renewable energy cases in Western Europe that have taken place, there really hasn't been that much of a question as to whether there was an investment or not. It's not that difficult to satisfy.
Thank you, Noah. The next point I wanted to cover is treaty structuring. Essentially, for that, investors should identify applicable treaties and check whether those treaties are in force. It is important as a next step to compare substantive guarantees and dispute resolution mechanism that we're going to talk about today, and as well as identify potential exclusions and other pitfalls in the relevant treaties. I think it's important to know that taking investment structuring seriously is something investors should definitely think about. First of all, analyzing political risks, plan for BAT protection when structuring a transaction or an investment. I would like to know that even after investment has been made, it may be not too late to adjust corporate structure to obtain a BAT protection. Obviously, with the help of counsel, investors should consider existence and type of arbitration clauses in various instruments that I outlined previously. It's important to know that treaties have different times when they came into force. Sometimes treaties can be terminated, so it's important to check those things. Jurisdictional issues might arise when you look at the definition of investment and investors. Again, it depends on a particular treaty, and where, for example, a shareholder is coming from, or it can be an individual, a nationality of a particular individual, and a treaty that essentially between Ukraine and that national's country, host country. It's important to compare the main substantive provisions of the treaty, and there can be also some tax carve-outs, which is a separate, quite a big topic to discuss. And I think it's important to know that tax advice on double taxation treaties should usually go together with BAT structuring and advice, because in an ideal world, structuring achieves both BAT and double taxation treaty optimization and protection.
Masha, before you leave this topic, sorry, go ahead.
And last point is that domestic foreign investment legislation is something that is worth checking, because not only a treaty can be applicable, but again, various particular instruments of the host country. And it's important to ensure that you look at those instruments as well.
So I wanted to add the present situation for those investors who find themselves not covered by an investment treaty or a powerful investment treaty. In the present situation, it may be too late. Now, it used to be that many of the cases, the decisions that came down from arbitral tribunals suggested that so long as this restructuring, so long as the structuring of the investment was done prior to adverse measures being taken, that was fine. And there was a famous case involving ExxonMobil against Venezuela, where a restructuring was done right in the middle of measures being taken by the Venezuelan government to take away first the revenues or the profits, and then the actual assets in heavy oil in the Orinoco Belt in Venezuela. And it was found there, and this is going back quite a ways, it was found there that jurisdiction would lie for any adverse government actions that happened after the restructuring. Anything that happened before was out. Anything that hadn't happened yet was in. Now that's evolved over time in a recent case against Australia by Philip Morris, and a few other cases have suggested that tribunals may deny protection to a restructured investment if, when the restructuring was done, let's say the writing was on the wall, even though nothing bad had happened yet. If the writing was on the wall, if you knew it was coming and that's why you restructured, then that would be considered to be, let's say, abusive, and therefore would not be given effect for purposes of the investment treaty. So here, where there's a long and drawn out discussion and many different not very helpful measures are being discussed by the government, it may be a bit late to restructure now.
Thank you, Noah. I agree with that, but obviously for any new projects, if they come to existence, it's important to keep in mind that you should consider those issues. Now, talking about substantive protections for investments, there are various protections a treaty or a particular instrument can provide you with. One of the main ones is no expropriation without compensation. That is usually something quite basic and available in most treaties that I've seen that Ukraine has concluded in the last, since its independence, essentially. Fair and equitable treatment, it's also quite a typical substantive protection, and you can see a definition of kind of fair and equitable treatment, a typical definition, which is investment shall at all times be accorded fair and equitable treatment, shall enjoy full protection and security, and shall in no case be accorded treatment less than required by international law. We can go into various discussions as to what that means, and there are many cases that cover these issues, but Things to keep in mind: whether actions by the state are unjust, unfair, arbitrary, inconsistent, disproportionate. For our purposes, I think legitimate expectations and inconsistency of states' behavior is also an important point to consider. And it's important to know that there are quite a few cases that look into balancing approach for regulatory changes. And this is something as well to consider. There's a big case law available on that. And last but not least, national and most favored national treatment. Essentially, that is something when a state, an investor should consider what other protections are available in different BATs. It's important to know that the applicable law to various instruments is a BAT or like international generally. It's a BAT or multilateral treaty, customary international law, general principles of law, and host state law, as well as a contract if one is available. And last but not least is a dispute resolution mechanism available in a particular instrument. First of all, it's important to ensure that there is a state consent to arbitrate. There are some old treaties that don't actually contain a direct, so to say, dispute resolution clause or a very easy one to read. But most of the recent treaties have dispute resolution mechanisms. And when one looks at that particular provision, there are a few things to keep in mind. Is the scope of the dispute relating to the compensation for expropriation. Some old kind of Soviet treaties were excluding compensation for expropriation in the calculation itself from the treaty. It's important to check the law applicable to the dispute, obviously, and pre-arbitration requirements that Markiyan and Noah are going to talk about a bit later today, and that is negotiation with the states, possible litigation, and cooling off periods, i.e. When you send a trigger letter and then how much time you have or when you can kind of start the arbitration itself. There can be also exclusions like fork in the road clauses, denial of benefits clauses, etc. Those two, for example, points relate to A, you shouldn't litigate the same point in the local court of that host state, and B, you should ensure that when you, for example, use a treaty between, say, the Netherlands and Ukraine, that you actually have the company active in that country, and you should look at the qualification of a particular treaty, in this case, the Netherlands BAT, to check that, again, you fall within the definition of the investor. There is also a menu of procedural options available in most of the BATs, and those include ICSID, Ancetral, Stockholm Chamber of Commerce, International Chamber of Commerce based in Paris. Ad hoc arbitration is also provided for in some old Ukrainian BATs. I would also like to add that there are remedies that Noah is going to talk about a bit later today, and in most cases is monetary compensation. Legal standard for that would be full reparation for internationally wrongful acts, and there should be considerations of interest, compound versus simple, etc. But that again comes when we're at the end of the arbitration process and we're talking about the damages and valuation of damages by various experts. One last point I wanted to add was in relation to review and enforcement of awards. This is a separate topic, quite a general topic, and we're not really covering this today, but just to know that awards and investment disputes are final, no appeals. A review of awards is possible only under limited circumstances, which differ between ICSID, for example, and non-ICSID cases. And one also needs to consider rules of state immunity, and most states allow awards or judgments against foreign sovereign to be executed against the commercial assets of that state. And then obviously there is a separate process of enforcing a particular award once an investor gets to that stage. I think on my end, that'll be it. I'll be happy to take any questions either via chat or a video.
Thank you very much, Maria. So if you have any questions, please ask them, or we can you can leave them in the chat. Any questions? So if there are no questions, I would give a floor to Markiyan to continue with the topic of negotiations with the government.
Thank you, Yaroslav. Good afternoon, everybody. They are usually, they're the usual suspects, such as the ministries of justice, economy, finance, the tax authority, and so on. But then there are those who may be relevant for the resolution of this particular dispute. So, for example, it is pretty safe to say that to negotiate the issues of disputes in the renewable sector, the Ministry of Energy would probably be included in that working group, and would probably take a very active role in trying in these negotiations and trying to promote the position of the state. You do not have to be surprised that the interagency working group also would include the representatives of law enforcement agencies, such as the Security Service of Ukraine, the National Police, the Prosecutor General's office. They're probably there due to formal reasons, but of course their function is to oversee the whole process and make sure that no interest of the state are unduly harmed. Again, as a matter of practicality, the interagency working group is this big, I would even say unwieldy instrument, because it is a collective body. It is not a single institution that can make decisions unilaterally. Even as a matter of practice, even getting everybody, and there may be some 12 to 15 people in that working group, even getting them in the same room or getting feedback from all these representatives on a single question may be difficult, let alone getting all of them on the same page with respect to a critical issue at the heart of the dispute. It is, however, critical to try to engage at least with the Ministry of Justice and the other key state bodies involved in this, perhaps the Ministry of Energy in this case, to get the investor's point or position across, and then push to have face-to-face meetings, or in our situation, perhaps video conferences, to try to talk through the issues and see if any of them can be disposed of by way of mutual agreement. Depending on how things go, the working group may designate a responsible body, a responsible individual, to be a point person, so to speak, in the negotiations, and that, of course, might make things easier from a purely sort of mechanical point of view. What is to be expected from the interagency working group and this whole process? It really depends. If we speak out of this particular context, there are certainly cases where this working group can do very little, especially if the alleged violations of the VAT or things at the heart of the dispute emanate, for example, from judiciary, from something wrong that is happening in the courts, or from a political process. For example, some law is being passed in the Verkhovna Rada, in the Parliament of Ukraine. There is very little in terms of influence on this process that the interagency working group, being composed of exclusively or almost exclusively of representatives of executive bodies, that they can influence these judicial or political processes. They probably, the most that they can do in this scenario is that they can agree, maybe not really willingly, but they still can agree to make various submissions and applications and requests to such bodies. For example, one classic example that we have employed a few times is for the Ministry of Justice to intervene as a third party in the judicial proceedings that are seen as problematic, just to not on the side of one party, but as a third party to observe the whole thing, and that is giving perhaps a very soft message to the court and the participants of the judicial proceedings that there is another angle to this situation. But in any way, doing so is really more on the shoulders of the investor to make sure that whoever is handling the process, whether it's executive, judicial, or legislative, to be aware that there is a formal dispute against the state of Ukraine related to what that process is doing to the investors' rights. In any way, it is worth noting that, again, as a very practical matter, it's a minor thing, but may have an impact on how things develop. That usually at the stage of negotiations, the Ministry of Justice and the interagency working group do not use external legal counsel. So Ukraine hires lawyers only when things get to arbitration, but in this process, they handled things themselves. That is not to say that the government side will be weaker or less experienced. Quite to the contrary, over the past few years, both institutions and individuals involved in that process on the Ukraine side, especially people at the Ministry of Justice, they have gotten to do this a lot. And they are indeed quite experienced in that. So they understand very well what it is about. They understand the nature of the BAT claims, and they understand how to handle it. They have gone through it many times, if we're completely honest with you. And they understand that the negotiations are, technically speaking, about one specific and a pretty narrow issue. There is whether or not there has been a breach of the BAT obligations. So formally, the negotiations would not be about the investment climate in Ukraine or the impact of the investment and the adverse measures on the state of Ukraine's electric grid. But these issues will always be at the background of negotiations, may come up at any moment, because in the negotiations, of course, the government will consider broader economic and political implications of the situation and how its possible resolution, whether it is a positive settlement or it is a negative failure of that process and the ensuing arbitration, how that will impact the way the government is seen in a broader sense. In this context, the investor obviously should be very well prepared to handle all these issues, both formally in terms of the BAT provisions and the claims the investor has under them, but also understanding the broader situation and whether any of that can be used by the investor to find common ground with the government. The investor should also be very clear what it would accept as a settlement. The investor probably should go, as in any negotiations, really should go through the process of determining what is the investor's, let's say, point of no return, or the point that beyond which no negotiations are possible. And furthermore, the investor should know whether what it wants is acceptable for the government and doable as a matter of Ukrainian law. There are several important considerations here. This is when we talk about the potential renewables cases coming from the renewables industry, it is a fairly unique situation for Ukraine, where the possible or the imminent measures by the government will affect an entire industry and not particular individual investors. It makes it, to be fair, it makes it rather difficult for one individual investor for any individual investor for that matter, to negotiate with the government. The government will understand that any concessions that it makes in one individual case will very likely be extended to other cases, whether by way of legal reasons under local law or as a matter of precedent. In this context, I know this has been discussed a number of times. It might be worthwhile for investors to consider sort of consolidating their positions, even if not in the same form of negotiations process, but sort of uniting their forces to pursue settlement together. Not necessarily in the format of industry associations as it has been the case now, but putting their cases together on a more sort of from a more substantive point of view. Perhaps there will be several groups of investors that are similarly situated for which it will be more natural to pursue their position together. This, of course, is pretty complex process that one needs, and the one that needs to be carefully coordinated. And even whether to pursue it in practice requires careful consideration, frankly speaking. The other important element for the purposes of negotiations is to see if the proposed if the mechanics of the proposed settlement are permissible under Ukrainian law. There have been two quite notable examples where the settlement that had already been reached between an investor and the government had come very close to failing. In one case, the parties, to be honest, it's hard for me to say which one, the investor or the government, neglected to take care to wrap up the litigations that were part of the root cause that led to the claims. And after the settlement agreement had been already signed and approved by the Cabinet of Ministers, which is always a requirement in this case, the courts found that the settlement agreement was not relevant to the legal issue put directly in front of the courts. And the parties had to really scramble to address the problems before the entire settlement structure collapsed. The other case that was related to an allegedly legal tax claim by the tax authorities. In that case, the settlement ended up being an equivalent to a write-off of the assessed claim by the tax authority, and that caused the Anti-Monopoly Committee to open an investigation into possible legal state aid against that investor, because that tax write-off may have been inappropriate. So in that sense, even if negotiations are going well, it's still important to understand that the process has to be completed, and there may not be necessarily an easy way to complete that process from a point of view of Ukrainian law. So that requires very careful consideration. Probably the final practical point that I wanted to make is that in a general default scenario, the negotiations between an investor and the government are handled not in a public way, with only relevant and very, very limited disclosures made only insofar as required by law. For example, when an investor has to make necessary reporting to the public markets. And it is also very common for negotiations to be handled only without prejudice basis, so that nothing of what the parties write and say in the process of these negotiations can later be used against them in arbitration. Well, that two points here really. As a matter of general advice, it is still very important to keep very close track of each step of the settlement process, as it may become relevant later, whether it's in arbitration or anywhere else. For example, and this is coming to the second point, in a situation where the investors and the government have engaged in a very lengthy and a very thorough and a very public discussion about the possible adverse measures against the industry, such as the renewable cases here in Ukraine that we are discussing, there's obviously a lot of stuff that is already on the record, both from the government side and from the investor side. And investors have to be mindful of what has been said, because that may have already prejudiced or impacted, in the very least, some of what their position could have technically been if that stuff had not been already on the record. So it would be I understand that it would be quite a painstaking work to look back on all those statements that have been made in many different contexts. Some of these statements may have been made not by the investors themselves, but for example, by individuals who can be, or organizations who can be attributable to such investors, for example, by industry associations. And that, to use a, let's say, to use a colloquial word, that can come back and bite investors in the end of the day. So in that sense, in that process, it is important to look both back and look forward, to look back at what had already happened, to really give yourself a fair assessment of the investor's case, to work on the assumption that all the weak spots, all the weak points in the case will be exposed in the process of negotiations. If they don't, then maybe the investor is lucky, but the experienced negotiators from the government side will try to make it happen. And also the investors have to look forward and to see how life may look like in various different scenarios. There is a quite distinct possibility that some measures are unavoidable, and maybe it's even the operating assumption at this point by the investors. And the investor has to, as I said, has to make a fair assessment on that basis about how to build its position in the arbitration. Beyond that, and beyond these practicalities that I've mentioned, it is a negotiation in the end of the day. There's really not a lot of framework in addition to what I've mentioned about how it has to be done. The parties can be convinced of stuff. We do know that the government has taken let's say the Ministry of Justice and the working group set up have been known to take steps towards the investors and to push for settlement agreements. And investors have been known to make concessions in order to avoid the more drastic steps that would have even greater impact on their investment. One thing that I have to be very frank about it, one thing that I have never heard of is of the government of Ukraine taking some retaliatory steps against the investors for filing trigger letters, for launching the cooling off period, and for engaging in negotiations. Of course, depending on how that goes, maybe the mood in negotiations will not be as sunny and happy, but that's a different thing. And nobody said that these things have to be easy. Either way, that isn't, as I said, that is an important phase of the process. Our advice is always to take it seriously and try to use the best of that opportunity that it given to the investors by the BATs, and really look at it as an opportunity and not as a 3 to 6 months period that you just have to suffer through before you can go and engage in a fun activity in arbitration. I'll be happy to answer any questions. I thank you very much for your patience, and do let me know if there's anything that I can respond to either here or in the chat. Thank you.
Thank you very much. Noah, do you have any comments?
No, I don't. I did see that there's a question from Mr. Kopcioglu, but it's one that relates to BIT consent to arbitration, so I can pick that up at the beginning of my comments.
Okay, good. And there was a comment from Alexander Pudin, who was asking whether changes to the model PPA may trigger initiation of arbitration. So basically for PPA and the arbitration clause which we have in the PPA, it is related mostly to commercial relations between the investor and off-taker. But the model form of PPA, it is actually adopted by the regulator. And so basically any actions of representatives of the state which are taken and which are adverse against investors, and in case if they actually significantly impact your project and and your expectations when you start the projects are very damaged, and there is a significant change of the regime. So technically, it may be a ground for initiation of investment arbitration against the state, not against the guaranteed buyer.
Perhaps I'll launch in, Yaroslav, given the late hour.
Yeah, so give floor to Rubins, who is very experienced in investment arbitration and is a guru, and he has experience in actually in cases in renewable energy. So he will cover aspects of initiation of investment arbitration and issues about damages.
Thanks very much, Yaroslav. I'm going to really condense things because I'm aware that we're running a bit late and people will probably have other things on their agendas after our scheduled end time. I did want to start with the question from Mr. Kopciolu, who says, who asks whether legislative support currently enables the BIT or other dispute resolution mechanisms, or is it expected that there will be an update in the law to allow that? Just to be clear, the investment treaties that we are talking about have been in place for a very long time. So Ukraine, over really since independence, has signed many, many investment protection treaties. It signed on to the Energy Charter Treaty at the very beginning in the 1990s, and those are ready to roll. That is to say, if there's a problem, the consent of Ukraine to arbitrate is already contained in the relevant investment treaty. All that remains is for the investor to accept that offer to arbitrate by effectively starting arbitration. Right? So nothing else needs to be done from the Ukrainian side in order to have that mechanism function. Now, today I wanted to talk a little bit about the procedural aspects of investment arbitration, and then a little bit about remedies. And I'll also be throwing in a little bit about the cases, if people can mute their lines, it'll help people to see me. Some of the cases that have already been decided in the renewable space in Western Europe. So what happens when investment treaty begins? Well, you've already heard in detail about the trigger letter or the notification letter, which is an important start. That's what launches the pre-arbitration period, if there is one, and in general opens the door to negotiations. More importantly, it enables the investor, after that time has passed, if no settlement has been reached, to initiate arbitration. And just to be clear, sending a trigger letter, sending a notification letter doesn't oblige the investor to do anything. It could never initiate arbitration at all, right? But if it does choose to do so, it opens the door to doing to that next more formal step by sending the trigger letter. The first formal step in arbitration is the request for arbitration or notice of arbitration, depending on the system of rules. Remember, Maria Pucina told you that most of these treaties include a menu of options. Most Ukrainian treaties have at least 2 options. The Energy Charter Treaty has 3 options of different systems of arbitration that the investor can use, and it is entirely up to the investor to select from that menu. The most common options are for Ukraine, ICSID, part of the World Bank. It's a specialized system for investor-state disputes. UNCITRAL arbitration, which is an ad hoc system of arbitration. And finally, the Stockholm Chamber of Commerce, which many of you will have heard about. And all 3 of those options are available under the Energy Charter Treaty. In any event, once the arbitration has been launched by way of a request or a notice of arbitration, the next step is the formation of the arbitral tribunal. Normally, it's composed of 3 arbitrators, and normally the investor will name one of the arbitrators in its request for arbitration. The ICSID process is a little bit more complicated, but I am going to generalize for for these purposes. Normally, there's a period of time that's given to the state to respond with its own nominee for arbitrator. And then there will be a system set up in the arbitral rules to choose the president or chairman of the tribunal. Most people think that's a fast process. It is not. It can take between 3 and 6 months for the arbitral tribunal to get set up and start working, start doing its work. And that takes, you need to have that in mind, that the process starts relatively slowly, and it's a good idea to be working on the case during that initial time. Once the tribunal is formed, it'll hold a first session of the tribunal, which is like a procedural conference. And that's normally done, even in normal times, forget about now, by video conference, by telephone, not usually required to have an in-person meeting. And there a schedule will be set up for the rest of the arbitration. Now, normally, these arbitrations take from the beginning of the written phase, so after the procedural conference, until the hearing, is normally 14 to 18 months. And it usually is composed of 2 rounds of written submissions, statement of claim or memorial, statement of defense or counter memorial, and then reply and rejoinder. So each side gets 2 chances to say what it has to say. And normally each side will submit with its arguments, will also submit all the evidence that it needs to rely on, both documentary evidence and any witness statements or expert reports. And expert reports particularly on damages, but in the renewable system, in the renewable cases, we've seen a lot of expert testimony on regulatory issues. Basically, the claimants trying to say that the new regime that's been put in place is not reasonable from a regulatory standpoint, and the state trying to use its expert to say, well, what we've done in replacing the old renewable regime is perfectly reasonable and in accordance with international practice. So that happens for 14 to 18 months. Often in the middle of that process, there's a pause for mandatory document production. So each side has to produce to the other side documents that it holds that are relevant and material to the case. And then when all of that is over, there is almost always an oral hearing. Now, in today's day and age, you may think that's rather difficult, and it is. We have had a number of hearings that have been canceled or delayed for a substantial period of time, and some that are going to take place by this very platform or ones like it, right? So by video conference, and we'll see how well that goes. The normal duration of a hearing is either 5 or 10 days. So 1 or 2 working weeks is very typical for this kind of case. After that, the tribunal writes its award. And that can take a very long time. Unfortunately, in most arbitration systems, there is no sanction or way to compel arbitrators to work faster. And these are very busy people. And often, well, almost always it is taking more than 6 months. I have awards out now where the hearing was in the summer of 2018, including one renewable case against Spain. So it's now been 2 years since the oral hearing, and we still don't have an award. So unfortunately, these are very long processes. This is not something where from day 1 to day 2, you're going to see a recovery. And in total, from request for arbitration to award, you're typically talking 3 to 5 years. People ask me often about the costs. There have been statistical analyses of the costs of investment treaty arbitration, and the consensus is statistically that claimants, investors, will spend somewhere in the range of 3 to 5, and on some counts, up to $6 or $7 million US to prosecute these cases. They are complicated. They require a great deal of work, and that is what the statistics tell us. There is, as a result, a very robust market today of what are called third-party funders, so investment funds who undertake to pay all of the costs of the arbitration in exchange for a substantial share of the recovery. It can be quite expensive capital, but in a case where the claimant is really strapped financially, it can be the only way to recover some value from the asset. And so there are a lot of these cases that are being funded. And I can talk more about that if it interests people out there. The other procedural point I wanted to touch upon is interim measures, because you've heard how long these things take, and in some instances the investor is saying, but things are going to get much worse if I have to wait 3, 4, 5 years before I get an answer from the tribunal as to whether what the state has done to me is right or wrong. And that's very true. All of the arbitration rules we've mentioned specifically empower tribunals to issue interim measures. And interim measures are normally measures designed to preserve the status quo, to prevent the state from taking measures that make the situation worse. And there normally needs to be some urgency about it. There normally has to be a significant harm that is imminent, and the measure that's requested can't be too burdensome on the state. Now you may say, well, what if the state is ordered to do something by the tribunal? How do you enforce that? The answer is you don't. These orders are not normally directly enforceable against the state. And although there are some exceptions, however, states normally try to comply with them, because sticking their finger in the eye of the tribunal that is going to decide their case is not a great strategy, right? So they try to comply. It's not always possible to comply. But you can see the continuing problem, which is, well, even if you get interim measures, you don't have a tribunal for up to 6 months. And then the tribunal has to hear arguments on the interim measures and decide the interim measures. What if it can't wait even that long? Well, certain arbitration systems have developed emergency arbitration procedures connected to the main arbitration, which can quickly result in measures issued against the respondent, often a state. And the most prominent one is the Stockholm Chamber of Commerce, which has a system for any Stockholm Chamber of Commerce arbitration. The claimant, or the respondent for that matter, but it's normally the claimant, can demand emergency arbitration, which results in the appointment of an arbitrator within literally 2 days, and the issuance or not, a decision on interim measures in no less than 5 days. So this is, if people can watch their microphones, it'd be great. So that's a very powerful tool, and for some that has led to choosing the Stockholm rules, where there's a menu of options. Even though in some ways it could be argued ICSID is a more powerful tool, only Stockholm among the options has emergency arbitration. And so if there's a need to preserve the status quo, often investors will choose that option. Right. So if there are no questions on the procedural side of things, first of all, Markiyan, I'll just touch base with you. Anything that I've missed in my blitz coverage of procedural issues?
No, that's pretty comprehensive, I should say.
For 12 minutes, not bad, right?
Absolutely, absolutely.
So let me talk a little bit about damages, and I want to talk about that just in really looking at some of the cases that have come before in Western Europe. And the problem that we face in trying to draw damages lessons from those cases is that the most of the renewable energy cases have not actually come to damages awards, particularly outside of the Spain context. There have been many cases, 30, 40 cases against Spain. There have been another dozen cases against Italy, and there were something like 10 cases against the Czech Republic. But in Italy and Spain, there haven't been any significant damages awards yet. In Spain, there have been a few. So I'll just talk a little bit about that. Marie already told you the general principle, which is for any wrongful act, a breach of an investment treaty, there should be full compensation. Full compensation means compensation that will place the injured investor in the economic position it would have occupied if the wrongful act had never occurred. Now that sounds pretty simple. In practice, it's quite complicated, particularly in renewable energy. And why is that? Well, the way you normally get at this is by taking a discounted cash flow or other way of finding the present value of future cash flows for the actual situation where the investment has been damaged. And you say, let's say it's today, or at the relevant time, assuming all of the things we know have actually happened, it's only worth $10 million. But if no bad acts had happened, it would have been worth $100 million by the same calculation. Well, the damages should be 90, the difference between those two. In renewable energy, the respondent states always argue the same thing, and Spain argues this all the time. They say, well, look, in the counterfactual scenario, what did you have a right to expect? Did you have a right to expect that nothing would ever change? Arguably, no. There could have been some changes which would have been fair. There could have been some changes which, although they were not great for you and would have reduced the value of your asset, it still would have been, let's say, not so bad as to breach international law. So your damages shouldn't be the difference between the ideal system or the system you were promised and the system today. It should be the difference between the system today and the system that's just bad enough that it doesn't violate international law. And in some of the cases against Spain, that argument has carried the day, more or less. So as you're probably aware, in Spain, the issue was a feed-in tariff regime put in place in 2006, which led to a massive oversubscription of particularly solar energy projects, but also other renewable energy projects. And the state was faced, particularly after the summer of 2008, with a massive deficit, so unable to fund the generous feed-in tariff. And so what it did gradually was dismantle that regime, first limiting the duration of the feed-in tariff, and then eliminating it altogether, and replacing it with a reasonable rate of return regime, where it set the reasonable rate of return at a very marginal amount above a risk-free rate. Very many investors, in fact, all the investors felt, well, if we had been promised only a very low reasonable rate of return, we never would have invested. Right now, in those 30 or so cases, a good couple of dozen have already been decided, and most of them have found that the change in the renewable regime in Spain was a violation of the Energy Charter Treaty and some bilateral investment treaties. And some found the other way, found that it was not so bad as to violate the provisions of the treaties. But in terms of damages, there's only been a few damages awards so far, in part because some of the cases have been split so that the jurisdiction and merits come first and then damages later. But one of the most prominent ones just came out in February of this year, PV Investors Against Spain, which was a group of 26 investors, and they received 91 million euros plus interest. And in that case, the tribunal found that, in fact, the investors did not have a right to expect the indefinite maintenance of the system of feed-in tariffs that had been in place, but only a reasonable rate of return. Now, they still got 91 million euros, but it was a very, very large project. So you have to keep that in perspective. In other cases, like Watkins Holdings, where the claimants got 77 million euros, the tribunal found to the contrary that the investors were entitled to expect what was promised to them. You might say that's kind of logical. You can expect the state to keep its promises. But as I say, that's not been the uniform approach of tribunals. And in that case of Watkins Holdings, the tribunal did a relatively straightforward calculation of what the asset would have been worth in the counterfactual scenario with the feed-in tariff in place, and compared that to the actual value of the asset. So a good result for the investors in that case. It's interesting to note that Spain often took the view, in fact, in almost every case took the view, that the investors should get zero in compensation. That was their primary position. And that was because they said, if we had kept the feed-in tariff in place, the entire system would have collapsed and you would have gotten zero. It would have been absolute destruction. We couldn't have maintained that system. And so we saved the system by reducing the benefits that you got. So you should be grateful to us because actually we prevented a much worse outcome. So you should get zero. You're better off in the actual scenario than you would have been if the feed-in tariff had been maintained. Now, that approach has not been widely accepted by tribunals. You'll be reassured to know. We'll see whether Ukraine, if we ever get that far, takes such an extreme position itself. It's interesting to note that in Italy, the regime that had been in place was relatively similar to Spain, but involved PPAs. Unlike in Spain, where energy was sold into the grid on a general regulatory basis. So in Italy, you would have thought it's a much stronger promise because the PPA had all of the relevant terms and those PPAs were taken out. Now, the way in which Italy got rid of its incentives regime was to offer 3 different options to the investors. It sounds similar to what Ukraine is contemplating. And as a result, there's been actually in the cases that came out of those measures, Italy has actually been relatively successful in beating back the investor claims, where it's been found that it is more fair, let's say, for the state to offer options to investors rather than imposing a single new solution upon them. In the Czech Republic has been relatively successful also. Their dismantling of the regime was rather different. The Czech Republic has been sued many times in investment arbitration, and so the Czechs took a rather sly approach. Knowing that the Energy Charter Treaty would be the most likely avenue of attack against it if they changed the regime. They also knew that the Energy Charter Treaty has a tax carve-out. It makes it very difficult to maintain claims against the state that are related to measures of taxation. And so rather than change their tariff regime, they imposed a 26% flat charge or levy on turnover of electricity sales. And so the main question in those cases was quite different. It was whether or not a 26% levy on turnover is or is not a taxation measure. And then the secondary question was, if it is not, or if otherwise there's no tax carve-out, was it fair to impose a significant tax like that? And it is, in general, even without a tax carve-out, a much harder proposition to attack a tax measure rather than a general regulatory measure like the ones we saw in Spain. Well, I think it's unfair to hold everyone any longer. And so what I'm going to do is I'm going to bring my comments to a close, even though there are, of course, many things I could have talked about today. But those are for another seminar and another time, or one-on-one conversations at everyone's convenience, which, of course, we welcome. So I'll pass back the baton, so to speak, to Yaroslav or to Markiyan to close us out. I see there are some questions from Murat. Should I address those?
Yeah, it's a long. There's actually 4 questions in one. Why don't we take it one by one?
Okay, so I can see them, Markiyan. I'll read them out.
Yeah,
so the first question from Murat is, what's the team's experience in FIT arbitrations in Europe so far? Have you been involved in any of the claims against Spain, Italy, or others? Answer: yes, yes, and yes. In particular, against Spain, we did 3 of those cases. Against Spain. One, interestingly enough, called Portagon, involves a lender to a renewable project rather than the equity holder. That's relatively uncommon. And we had one wind power called Eurus, and solar, that's called Sunflower. And on all of those, we're waiting for awards. The Czech Republic one that I was involved in settled, and Italy, they decided not to bring the claim. You can see I've gone over the results of those in general of the cases. In Spain, obviously, they have not been very successful. Italy and Czech Republic more successful. Number 2, the state already hinted that they will argue that all of us should have known that the tariffs are unsustainable, and we should have known the off-taker will have liquidity problems. What could be a defense to that? Well, everything depends on the facts. Everything depends on what was promised to you. So it is a reasonable defense of the state to say, look, we never promised it would be forever, and you should have known that there was an expiration date on it, right? Now, that works so long as there is no statement in the law, in the regulations, the parliamentary debates, or the road shows that some states do to attract investment about the duration. Most states, create the impression when they're trying to promote renewable energy that, to the contrary, this is a permanent measure, right? And indeed, the response of the Ukrainian government suggests that's what they thought too, right? They thought at the time it was a permanent measure. So what is really seems to be the most important turning point fact is, are the measures retroactive or not? Because the normal way that a state can respond to a renewable program that is too expensive is to say, I've set a cutoff date for investment. Anyone after that cutoff date, you get nothing, right? But people know then that I shouldn't, if that matters to me, I don't invest. But to existing plants, to change existing plants, the way that they're treated, that's generally considered to be unfair. But it's a good question that we could have a whole nother seminar about what is it, reasonable expectations, and does it really matter? And but in brief, okay, number 3, will projects that we have stuck with at the date of financing with the banks, not built or commissioned, are they eligible for claims in your view? Excellent question. Right. So I know there are a lot of those out there. And I would say it depends how far you got, right? So if the financing is locked in, if there are feasibility studies, if there is some investment on the ground, jurisdictionally, you need to demonstrate an investment. And there are cases that say that pre-investment expenditures, studies without feet on the ground, are not enough jurisdictionally. There's some debate about that. But generally speaking, if you're promised X by the state and you get Y, then you can recover. Now, the question is, how much will you recover? And generally, you will tend to get less recovery the less you've done on the project, right? That's because there's more risk involved, commercial risk involved in a project that you have not yet built. And so, for example, the discount rate will have to be higher, or there will be other, there will be other ways to reduce the net present value, generally speaking, of an early stage project. And number 4, do you know any arbitration funders that are open to look at funding the arbitration costs of the disputes in Ukraine rather than Europe? Yes, absolutely. I know that there are many cases against Ukraine that have been funded. I know that for a fact. I won't say how I know that for a fact, but I know that for a fact. Generally speaking, Ukraine is considered to be a medium rating debtor. So it's not an Argentina or a Venezuela or an Ecuador or a Bolivia, where there are lines and lines of investors and a state that's just refusing to pay anything. On the other hand, it's not an oil-rich state with no financial problems and so on. You know, you could just imagine, you know, one of the Gulf states would be a very high credit. So Ukraine is a place where funders are very interested, and yes, we know them. Great questions, thank you. Okay, there's some more. I'll take them so long as people are interested. I don't want to, let's see where, okay. From Antunia and Partners, no very objective analysis. Congrats, thank you. Congratulations on your recent QC. Thank you very much. You definitely deserve it. Well, thank you once again. Okay, I guess that's it. I don't see any more questions here.
Yeah, no more questions at the moment. And if you would like to ask a question in verbal, please say it. And yeah, there is a question.
How do we, so Noah, how do we understand the reasons for the Spanish, Italian, Czech ECT decisions going either way in relation to the same legislation? Do you expect similar splits? That is an amazing question. I love that question. In international arbitration, there is no binding precedent. So that means that 10 different tribunals examining exactly the same issue under the same treaty could come to 10 different solutions to the same problem. There is nothing wrong with that from a legal perspective. There's something wrong with that from a logical perspective, but not from a legal perspective, right? And in fact, if a tribunal relies on another tribunal for its decision, arguably that is legally wrong. They're not allowed to do that, although of course, every tribunal wants to be as consistent as possible. Different arbitrators have widely different views about almost everything, but particularly about the level of deference that should be given to regulatory decisions taken by states. That's part of the calculus that goes into choosing arbitrators in the first place. But every combination of 3 arbitrators with their particular chemistry and their particular legal and cultural baggage leads to a different result. If we go back far enough, there was a very famous set of cases called the Lauder CME cases against the Czech Republic. Nothing to do with renewable energy. Actually, it had to do with a naked weather girl. It really did. It had to do with a Czech television station where the lady who told you what the weather was going to be didn't wear a shirt. It was a very popular television station in the early 90s in the Czech Republic. And an American investor, very famous guy, Ronald Lauder, got pushed out of that very profitable venture by a local partner, helped by local regulatory authorities. And 2 cases were launched against the Czech Republic, one by the company and one by its shareholder. CME was the company, Ronald Lauder the shareholder. 2 different treaties, 2 different cases. They went on almost simultaneously together. They came to decisions within weeks of each other, and they were exactly opposite. Same facts, same everything, same case. The Lauder Tribunal dismissed the case as not being in breach of the treaty, and the CME Tribunal found that there was a breach and awarded hundreds of millions of dollars against the Czech Republic. So that's just a lesson to say, do I expect similar splits in potential claims against Ukraine? Yes, not only for that reason, because there is a general consistency, and there's more and more over time, all right? But the facts are different in every case. And one of the most important facts will be, when did you invest? How much did you know when you invested? What were you told by the government when you invested? All that is specific to each project, right? And so that's one of the explanations for the splits in the Spanish cases, is that some were late investors, people who invested very late, very close to the deadline, when there was already discussion about dismantling the renewable regime. And for some of those cases, the tribunal said, no, you really knew what was going to happen. You invested taking that risk. And so we don't think it's unfair what happened to you. Right? Whereas investors who came in quite early could not have seen the writing on the wall, so to speak. I hope that helps. Anyone among the presenters want to add anything to that? Nope. Okay, there we go.
Yeah, thank you very much. We don't have any more questions, and if you have any additional questions, you can send us by email. You have contact details of our representatives. We will be able to answer them by email. And once again, apologies for technical problem which we have faced. But a part of this, I think that the event was very good, and so we hopefully Ukraine will avoid the investment arbitration claims, but you never know, and everyone should be ready in case if anything goes wrong. On this, thank you and goodbye.
Thank you very much.
Thank you very much.
Bye.